Once again, an order for forfeiture judgment landed on the 18th of March 2024. Those of you following along in your bundles, you can find it on page 12 to 30, and on your summary pages, page 2, rolling over to page 3. Full citation, N.A.M versus M.S.M, 2024, ZA-FSHC 97, for those of you taking notes. The facts of this matter, essentially, the plaintiff sought forfeiture of 50% of pension interests. Parties were married since 2017. The plaintiff alleged that the defendant did not contribute to the growth of the joint estate, particularly plaintiff's pension fund benefits, and that the defendant never had a fixed income or permanent employment. He continually changed jobs. He failed and or refused to financially support plaintiff or the minor daughter born of the marriage. And then the plaintiff made a very interesting allegation, a very important allegation for these purposes, that the defendant is not only currently unemployed, but also refuses to look for work. So manifestly and patently and habitually unemployed. Then, as an aside, I would also mention that the defendant, who is impugned in this instance, also sought spousal maintenance from the plaintiff, being the party that was asking for forfeiture. Now, what is interesting in N.A.M versus M.S.M is the court takes a points-based approach to the 3 factors in terms of forfeiture. And I'm not saying scoring points. The court essentially looked at each point individually in terms of duration, misconduct, circumstances. The court then also did a fairly good job of restating the principles set down in the vacant judgment, which is the locus classicus really in respect of forfeiture. Now, it bears mention, obviously, since there was a claim for spousal maintenance, that the Section 7.2 of the Divorce Act factors were also looked at. In this instance, forfeiture was granted in respect of 50% of the plaintiff's pension interests. Obviously, in this instance, the spousal maintenance claim was also less than successful. And what is nice, in paragraph 65, the court sets out the principles again. What is required of the court is to consider the 3 issues set out in Section 9.1 in broad terms, and then to make a value judgment whether the defendant would be unduly benefited if a forfeiture order is not made. An undue benefit is one which is disturbingly unfair, and I quite like the clear enunciation of disturbingly unfair. It is something that one can really nicely use as a test in terms of argument on a forfeiture. On a careful consideration of all the facts, I came to the conclusion that the defendant would unduly benefit from the plaintiff's pension fund if forfeiture is not made in order of court. And then paragraph 58, where the court looks at the issue of spousal maintenance. From the language of the enabling provision, it's clear that the awarding post-divorce spousal maintenance is purely discretionary. The discretion of the court should be exercised judicially according to established rules of law and practice, and in making a determination of maintenance, consideration of justice must prevail. The factors that a court will take into account when awarding maintenance are not exhaustive, and the court has a very wide discretion whether or not to grant maintenance. Grant a maintenance order, the amount payable, and the duration of the maintenance. That's paragraph 58. Very importantly, folks, to juxtapose Section 7.2 and Section 9.1, specifically because of that issue that the factors that a court will take into account when awarding maintenance are not exhaustive. You'll note Section 7.2 has a provision, any other factor. I've seen quite a lot of people plead a forfeiture also having regard to duration, misconduct, circumstances, and any other factor. And there are, in fact, some textbooks which propose that it be pleaded that way, but that is not what the Act says. The court does not have the discretion to take into account any other factor. It is limited by the legislation at present to circumstances, misconduct, and duration. Sure, let me not fall over while I am on screen with you fine folks. This was N.A.M versus M.S.M, Bloemfontein High Court, Boonside AJ, and that is safely referenced ZAFSH C97, and that is 2024.